Hi everybody, Jorge Rivera here with the People's Resource Center and your Tenant Tip Tuesday. Thank you so very much for joining and for watching. Let's get started with a little bit of grounding as always, just so that we're taking care of ourselves through stressful times. So let's just start by just taking in a deep breath. We can just imagine light coming into our bodies and then just bringing it down. Another deep breath. And slowly releasing. And slow deep breath. Nice cool energy filling our bodies and then out. And one last one. Then, all right, way to go. Well, let's get to your Tenant Tip Tuesday. Thank you once again for joining us. We are going to stay on the same theme of unlawful detainers and the eviction process. We actually came across these really great handouts that we wanted to share with you. So be sure to check out our social media pages for images of the eviction process so that you can better understand how it works and what to expect. You should not be afraid of the eviction process. The eviction process is there as a tool for you as a tenant to be able to stand up for your rights and to defend yourself against any unlawful evictions or unnecessary evictions. So we wanted to talk about the eviction process a little bit today. And it always starts out with some sort of notice from the property owner. And this can be a 3-day notice to pay or quit, a 3-day notice to quit, a 30-day notice, a 60-day notice, a 90-day notice, any type of notice that will eventually lead to the property owner possibly filing for an eviction. And so for the first phase, it's just receiving that notice. And when you get that notice, it is that in and of itself is not an eviction notice. That is just a notice for you to be able to do something, whether it's to pay or quit or to perform or to correct some sort of violation in the terms or anything of that sort. Or maybe they're giving you a 60-day notice because they're thinking about selling the property or something to that effect. But you should get a notice first and foremost, and then you can always reply to that notice if you think that that notice is insufficient or it's invalid. That's what we're here for as tenant counselors. We can help you verify that information and be able to guide you on what steps to take next. Now, after that notice, that time of the notice expires, like after the 3 days for a 3-day pay or quit, or after the 30 or the 60-day notice, after that expires, then the property owner can choose to file for an actual legal eviction. And they'll go to the court, they'll pay their fees, and they'll file what's called an unlawful detainer. And then that unlawful detainer is then sent to you as a tenant. The owner is either going to have somebody come and give it to you at your door, give it to you in person, post it on your door, and you probably receive a copy of it in the mail as well. And just to make sure that you are notified that an unlawful detainer has been filed against you, the court will actually send you a copy as well, just to make sure that you received it. And if you believe that an unlawful detainer has been filed against you, but you have not received anything, you yourself can go check at the local courthouse that pertains to your area and check to see if an unlawful detainer has been filed. If it has been filed and you hadn't received anything, then the courts will go ahead and send you a copy of that unlawful detainer to you, usually by mail. And once you receive that unlawful detainer, whether it's by the owner posting it on your door or through the courts sending it to you via mail, you have 5 business days in order to respond. You have to remember that an unlawful detainer is a lawsuit against you for some reason that you are unlawfully occupying or detaining their property. So you, as the defendant, are going to have to respond to that lawsuit. And you have 5 business days from the time that you receive your very first copy You have 5 business days in order to reply. Now, you can reply on your own, and there are actually tools that have been developed, online tools that have been developed to help you reply on your own. We recommend that you try to consult with a tenant attorney or an eviction defense attorney to help you file the answer. And very, very importantly, it is your right when you're responding to an unlawful detainer to request a jury trial. We recommend it. Many eviction defense attorneys also recommend it, that you request a jury trial in your response to an unlawful detainer. Now, if you don't respond to the unlawful detainer within 5 days, you may actually have an opportunity to respond late if there's a good reason as to why you didn't respond within the 5 days. Let's say that you were in the hospital and you never received it. You have the opportunity to try to file a response after the fact, and then it's at the discretion of the commissioner or the judge to either grant you that response, or they might actually just default to the property owner and give them the win. And if you did file, then you just await the actual court date that is being assigned to you, and then you go to court on that date, ready to go. Hopefully you're there with an attorney that's representing you, and then you'll probably go through the following steps after that. If you didn't file on time, hopefully the judge will give you an actual allowance to go through with the trial and with your defense. But sometimes the judge will actually just grant a default win to the property owner because the response wasn't received on time. So if you did respond and you received a court date, then you actually then go to court, you present yourself hopefully with your attorney, and more times than not, in our experience, the judge or the commissioner is going to want to encourage both sides to try to settle out of court. And so you will probably go into a room, negotiate on your behalf with your attorney and the other side's attorney, and then you'll try to reach some sort of settlement. If you don't settle, for whatever reason, you're not in agreement with the actual offer that's being made to you, and you have a good defense, then you might just go to trial. And then that's when the attorney that's hopefully representing you will then take you through the trial process and all of that great things that happen during then. If you do settle, then you can also request that your case file be sealed as part of the settlement agreement, so that there is nothing that actually shows up on your record. No negative things, no dings on your credit report, so you don't have to worry about that. So always, if you're going to be representing yourself without an attorney, try at the very least to get your record sealed so that you don't have any negative dings on your credit report that prevents you from finding another place to stay. Now, if you go to trial and you win, then there's some things that happen after that. Like, you win your right to remain in the unit. If there's any rent that is owed, you're going to be expected to pay that rent as part of your win. You have to come current with your rent. If you lose, then it's very possible that you're going to be given a date as to when you're supposed to be out of the unit, and you will probably receive a ding on your credit report as an eviction. So you want to weigh out how good of a defense you have, weigh out whether or not you want to go to a jury trial, weigh all of those factors out, and hopefully, again, you're doing this in consult with an eviction defense attorney that is able to give you good information and give you their perspective and give you legal advice in order to do so. So that is pretty much the eviction process. There's one more thing. If you do lose, or even if you reached a settlement, you might be given a date that you're going to be expected to physically be out of the unit. If you are still in the unit when that date arrives, that is when the sheriffs might actually come and knock on your door and ask you to leave. They vary as far as how much time that they give you to actually move out. We've seen cases where it's just a couple of hours, and we've seen cases where it's been a couple of weeks. So it can vary depending on the sheriff and on the circumstances. There's no set date, no set amount of time that the sheriff is supposed to give you in order to have you physically move out of the unit. So that is sort of like a summation of the eviction process. Again, the eviction process is there to help you defend yourself and advocate for your rights. We always recommend that you go through the eviction process, that you actually request a jury trial, as is your right to request a jury trial. And you go into the negotiations ready to try to reach a settlement with the other side, and or you are ready to defend your case in trial when you do so. So that pretty much sums it up. If you have any other questions, that's what we are here for. Reach out to us at our tenant counseling hotline. We deal mostly in Southern California. So if you have any other areas that you need covered, you can reach out to us and we can try to put you in contact with somebody in your area. That was a lot. So let's just take a deep breath in and out. Just to let that all settle. Remember, we are better together. We are stronger together. If you have neighbors that are going through the same thing, try to get together with your neighbors and do it collectively. You have a lot more strength and a lot more power when you are in a group than when you are on your own. And if you need any legal counsel or advice, we can help you connect to any legal resources if you might need it. And if you have any questions, just reach out to us on any of our social media platforms or reach out to us on our tenant hotline. So that'll do it for this week's tenant tip. We're going to actually post in our social media pages. We're going to post the link to that tool that will help you actually file a response to your unlawful detainer on your own if by any chance you do not have an attorney. You can file your response on your own, and then after the fact, go find an attorney so that you can try to amend your response with the attorney's assistance. So if you're running out of time and you have to respond within 5 days, just submit a response, try to find a tenant attorney that can help you, and then go amend your response if needed. Okay, so that'll do it for this week. Thank you so very much for joining us. Again, we're trying to educate as many tenants as possible on what their rights are so that they can advocate for themselves and for others. So please share this video out. It just takes a repost or a share on your social media, and always go to our YouTube channel for more tenant tips. And remember to subscribe and to click the bell notification so that you can be notified of any new videos that we post. So thank you so much again for watching. I'm Jorge Rivera with the People's Resource Center, and this has been your Tenant Tip Tuesday. Bye-bye for now.